Joseph, years ago, I listened to a collection attorney suggest using a writ of execution to have the sheriff visit the debtor's house. And like I mentioned earlier, take his beloved pet for the sake of leverage, because often at that point, the debtor will just get out his checkbook and start writing the check to the creditor. Does that sort of thing really happen in your practice enforcing judgments?
Well, first of all, let me just be clear that anytime assets, any property that's taken, it's taken for the financial value, not for leverage. That would be an improper purpose, and that would be a great way to have your levy undone. So if a pet were valuable, say a show dog or a rare bird, then that would make sense. But if you have a mutt that's 10 years old, near the end of his life, no real value other than sentimental, the judge would probably put a kibosh on that.
Oh, I see. So if you start going through the house and pointing to family portraits on the wall and start taking those, that would be only for sentimental value and for leverage and not a proper purpose of judgment enforcement.
Exactly right. And there are exemptions that exempt normal, typical household goods. Fine art, whether or not it has sentimental value that has real value to it, is always available for seizure.
Okay, interesting. Well, that's an important nuance that that was not related when I watched that in a video by another judgment enforcement attorney years ago. I wonder if you, nonetheless, you must have some interesting stories from your practice in judgment enforcement and defense. I wonder if you could tell us one.
Sure, I'll tell you an urban legend that my firm may or may not have been involved with. Small judgment, about $75,000. The lead attorney decided to examine the debtor. And during our discovery, we discovered that the debtor had a girlfriend. And so the lead attorney decided it might be beneficial if we examined the wife, the girlfriend, and the husband all on the same day. Let's just say that those examinations never took place. Checkbook came out and the $75,000 was satisfied.
Now that's very clever. So that's so obviously the debtor got service of a copy of those third-party judgment debtor examinations.
The debtor must be notified of everything that's filed, whether or not it involves them directly.
Yeah. Well, and that's and obviously that was done partly for leverage, but ostensibly they may have some useful information as well. So it was still a proper purpose.
Certainly.
The leverage was just a bonus.
Yes.
Got it.
Another example, if you're interested, is a little more technical. There was a debtor. It was a bicycle company, and they had a large judgment, $600,000, $700,000 against them. They had been around for 30 years. They had developed intellectual property. They went into bankruptcy, but they created a shadow corporation in which they transferred all their assets except for the intellectual property. And so the leverage that we were able to put on them was, we're going to sell your intellectual property for $1, and the creditor will buy it, and you will forever be without your intellectual property, or you can settle this judgment. They ended up settling for about 125% of the judgment.
Wow.
Because the alternative would be to lose their IP.
Yeah.
The golden goose.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.